So Nick, how are you?
I'm getting you, Bruno.
I'm good. I'm good. So I have to ask, so everyone knows, Nick is won't be able to answer too many questions today because of something that happened over the weekend. But I'm sure people would die to actually figure out or to learn what you did over the weekend.
Oh no, I had a little bit of fun. I was on the bush actually, and unfortunately, while we were sitting on the bush, we had a lovely fire run through. So I spent my weekend doing a little bit of firefighting, and unfortunately, I've ingested a little bit of smoke and ash, so my
Sure.
throat's a little bit gone. So thank you for saving me and helping me out. I'll answer the question, or I'll ask the questions if you can answer.
Sure.
That'll help me out a
Sure.
lot.
Yeah. Cool. Awesome. Awesome. Awesome.
Perfect. So what we want to start with, Bruno, is just there's obviously part of what we do is we keep our eyes locked on case law and developments, in the law, just to see where everything is going. And the first thing I just wanted to ask is, has there been any interesting case law that you've seen recently, something worth noting, that you'd like to let our viewers know about?
Sure. So as most of the viewers know, a lot of my clients are sell and execution clients. So sell and execution clients, also known as like sheriff auction clients. These are guys that go and basically attend auctions via the sheriff to buy distressed properties most of the time. And these properties obviously come about or get to auction due to some kind of default. Oh, usually some kind of default. So there's a judgment against someone, and that person happens to own a property, and that property is probably put up for security for some reason or another, and the property is sold in collection of whatever loan or debt or whatever the case is, right? So that's foreclosure, sales and execution, and why sheriffs typically do this. Now, the most common type of sale and execution is the one with a bank as a lender. A lot with mortgage bonds, they lend money to the person that owns the property, they register a mortgage bond. If the person that owns the property doesn't pay, they use the property as security in order to collect that debt, right? So that's the context behind it. So a lot of my clients play in that space. Now, so there was recent case law that came out, which is quite interesting for these clients and something to watch out for, especially as a purchaser, because it does create, unfortunately, a vacuum or a gray area in our law where we kind of don't know where we stand at the moment. But I'll explain this in a second, and hopefully there'll be some kind of clarity sometime soon. Long story short, so the process started with an eviction application that the owner of the property brought against occupiers that were staying in that property. This was done through magistrate's court. The magistrate's court then postponed the matter as sine die, which is basically indefinitely or until set down again, pending the outcome of a high court application that the occupiers were bringing to the high court. Now, this does happen often, so people do know in eviction proceedings, especially in magistrates courts, you do typically tend to find that magistrates might decide to leave a decision to the high court and penned like eviction proceedings in the mag court. This is often also why we bring some of their applications in the high court, because judges are less inclined to do something like that. Anyway, in the high court, the application was brought by the occupier. And this is where it gets interesting. So the occupier was the owner of the property back in 2001, right? So 20 years ago. They were the owner of the property, and they had a loan with NBS, which like now no one's even heard of. I mean, it's so old. I still remember NBS being that Wimbledon sponsor with the parrot, if I'm not mistaken, or any case, yeah. So NBS long gone. So 2001, they had a loan. There was a mortgage bond, presumably registered in favor of NBS. NBS since then went through some mergers, acquisitions, etc., became NBS Berland, then became People's Bank, and then got taken over by Nedbank, which was a party to these proceedings. Long story short, this property was sold in 2001. In these actual proceedings, there was no evidence that the property was sold in a correct way. So there was no evidence that the sheriff sold it, no evidence that a warrant was issued, no evidence that due process was followed, the rules of court or anything like that. And that's obviously the most crucial fact here that people need to realize. This isn't to say that you can set aside any sale that happened 20 years ago. It's the question of, was due process followed? Because there's presumably and years and years and years of court records that go back to the 1900s. So you should be able to track something, right? So in this current case, there's no evidence the property was properly sold. So the question before the court was, and since then there's been subsequent owners. So the property was bought in 2001, was sold. So I think this was about the fourth owner somewhere in line. So before the court, the question was, is the court allowed to set aside a sale and execution like this? On what basis are they allowed to, and does the current owner have any protection by way of being a bona fide purchaser? This court went through a whole bunch of case law, and the conclusion that it made was, since the first sale was completely invalid, the real agreement was defective, basically meaning that the sheriff, if it was even the sheriff, or anyone who sold the property, didn't actually have any right to sell the property, by virtue of which ownership could never have passed. And no matter how bona fide any purchaser is, you can't transfer more rights than you actually have, which is the old saying in our law. So long story short, and this is very exceptional circumstances, the court did actually set aside the sales, all the sales, returning the property back to the occupiers. Now, I have to kind of draw a couple of, make a couple of warnings for starters, and also qualify like this type of situation. For starters, this is exceptional. The fact that you can't find any record at all of a loan existing, a sale and execution taking place, or if the sheriffs have no records, is for one of various reasons. Either nothing actually took place and it was completely unlawful, or unfortunately, it's possible that the litigants didn't ask enough questions and didn't go to each sheriff and try to figure out how it actually took place and whether there was any validity. Because if they did, obviously there might be no records of it. But normally there's a court file, there's sheriff's records, there's attorneys on record. Very often, like, the big banks are still around. So it is very, very, very unusual that property gets sold on auction, especially nowadays. Because if it were to happen now in 20 years' time, we start asking this very same question, it's doubtful that this would happen. Because now there's so many orders you need to obtain first, so many tests, so many, it needs to go before open court, etc., etc. Very unlikely. So don't be scared of buying properties on auction for fear of this happening. All this kind of says is, if there's something materially unlawful and illegal over the sale of the property, the courts are willing to set it aside. Second thing that you need to remember is this judgment sits at a lower level of, our high court jurisprudence. There's still full bench, there's still SCN, there's still constitutional courts, and I cannot see how this won't go to those high courts, even if simply because the granting of an order, simply setting the sale aside, doesn't deal with how we're supposed to go back in time and deal with those problems, which just opens the door for more litigation, because now all these subsequent owners are going to be fighting about how they're supposed to get money back, and there's tax implications because maybe capital gains was paid somewhere along the line, loans were granted, interest was charged. If you just set things aside, it doesn't really set a motion on how to reverse things. So my humble opinion is that if a court is going to go so far as to set transfers aside, it may be prudent to kind of to deal with the circumstances of the consequences, because now you're expecting another court to reassess everything and come to consequences that might differ from other consequences. It will be rather complicated. So yeah, that's the case. So don't be scared. Nowadays things do work differently, but it's not to say that if something was materially wrong, the courts won't set the sale aside. So the courts do have the power to do that. I've only seen it happen literally, maybe 99 out of 1 out of 100 deals. So it's not something I would be particularly fearful of.
Yeah.